Listen-only mode.
Hi everyone, and thank you for joining me for this month's People Hour. In today's session, I'm going to look at the concept of pre-termination negotiations and also at their forerunner, the without prejudice rule. So what I'm going to be talking about are those tricky conversations that you might sometimes need to have with an employee about them exiting their employment on agreed terms, and in particular the extent to which those conversations are truly protected from being aired before a court or tribunal. So, as you'll be aware, there are two distinct concepts which apply. Firstly, there is the without prejudice rule, which has existed for some time, as you may all be aware. Secondly, there is the concept of a pre-termination negotiation, also commonly referred to as a protected conversation. And the ability to hold a protected conversation was introduced by government legislation in 2013. And at the time, it was widely thought to widen the scope of the existing without prejudice rule. So what I'm going to look at is whether in fact that is the case, and at some of the key differences between the without prejudice rule and protected conversations, and at some of the pitfalls in relation to each concept. With each concept, there are some significant limitations which can result in protection being lost. So finally, I'll focus on what practical steps you can take to ensure that the amount of protection that you gain when having these conversations is maximised, and also how you can protect yourself from claims in the event that you do lose the protection under a without prejudice conversation or a protected conversation. As always with People Hour, there is the ability for you to ask questions as we go along using the questions facility on your screen. If you do ask a question, then I'll either pause and attempt to answer it, if I can do, during the course of the webinar. If I can't answer it at the time, then either myself or your usual gunnercooke contact will be in touch afterwards, and hopefully we'll be able to answer your question. Okay, so on with the session. So firstly, what is the without prejudice rule? This rule, as you may be aware, was established through case law many years ago prior to the introduction of protected conversations, and it continues to exist alongside the law on protected conversations to date. So we have the situation where we still have without prejudice protection alongside protected conversations. The without prejudice rule, in essence, prevents statements which are made in a genuine attempt to settle a dispute from being put before a court or tribunal. And one of the main reasons for the introduction of the without prejudice rule was public policy of encouraging parties or potential parties to litigation to settle their disputes out of court. The rationale being that if you are able to discuss those disputes freely and to negotiate freely, you're more likely to achieve a settlement and therefore avoid court proceedings. But the main limitation of the without prejudice rule, as I'm sure many of you will be aware, is that there must be an existing dispute with an employee. And what we know through case law is that a dispute is construed narrowly. Some of you may be able to cast your mind back to 2004 and the leading case of BNP Paribas and Mezzatero, where it was held that a grievance raised by Miss Mezzatero did not constitute a dispute. The circumstances of the case were that Miss Mezzatero raised a grievance upon returning from maternity leave to the effect that she had been prevented from returning to her old job after maternity leave. She was then invited to a without prejudice meeting by BNP. What the EAT said is just because an employee has raised a grievance, it doesn't necessarily mean that there is a dispute. Their rationale for that decision was that an employer can either uphold a grievance or dismiss it for reasons which are, in either case, acceptable to the employee, meaning that the parties may never actually end up in a dispute at all. Furthermore, the court in that case held that even if the grievance had amounted to a dispute, then the purpose of the without prejudice meeting with Ms. Mezzatero was not actually to resolve that dispute, i.e. to resolve the grievance. It was rather to terminate her employment. Therefore, the purpose of the meeting was not to settle the existing dispute. Therefore, it became clear following that case that it can't be assumed that just because an employee has a grievance, there will be a dispute in existence. Another case which looked at whether a dispute was in existence was Hudson and Oxford University. And in this case, Mr. Hudson was dismissed by the university and he appealed against his dismissal. The university wrote to Mr. Hudson on a without prejudice basis during the appeal process, stating, "There is no prospect of you returning to work for the university in any capacity. It would clearly be desirable to find a solution, but that would not be possible unless you accept that a resumption of the employment relationship is both unrealistic and unworkable." The EAT said that since Mr. Hudson wanted the decision to dismiss him to be overturned on appeal, the statement that there was no prospect of him returning to work in any capacity was not a genuine attempt to settle the dispute, because the dispute was about his dismissal being overturned. I think this case clearly shows, in addition to the Metzger case, that there is a narrow definition of a dispute. And this has meant that in practice, it has been difficult for employers to establish that that dispute has existed, such that a conversation is genuinely without prejudice. And in practice, certainly before protected conversations came along, conversations often took place in the knowledge that there may well not actually be without prejudice and may well end up being disclosed to a court or tribunal. A further limitation on the without prejudice rule is that protection is waived where there is what's known as unambiguous impropriety, a bit of a mouthful there, during a without prejudice conversation. Basically, on public policy grounds, this prevents an employer from acting in a way that is discriminatory or where undue influence is applied during a without prejudice meeting. So in the Metzger case, there was unambiguous impropriety where Ms. Metzger was told during the meeting that her role was no longer viable in circumstances where she had raised a grievance about maternity discrimination. It was found that the act of telling her that her role was no longer viable during that meeting was in itself an act of discrimination. Therefore, the employer could not rely on the cloak of without prejudice. Unambiguous impropriety can also cover situations where undue influence is placed on an employee not to accept a severance package. So the classic, if you don't take this package, then the writing's on the wall for you, you'll be out the door type conversation, clearly would result in without prejudice privilege being waived. So that's just a brief overview of without prejudice privilege. I'm now going to look at the concept of pre-termination negotiations, also known as protected conversations. So as I've already mentioned, the concept of a pre-termination negotiation was introduced in 2013, and this was done by inserting a new section 111A into the Employment Rights Act 1996. One of the key aims of this legislation was to encourage open and frank conversations beyond the scope of the existing without prejudice principles, which, as we've heard, require there to be a dispute between the parties. So what section 111A says is that, firstly, any evidence of pre-termination negotiations is inadmissible in unfair dismissal proceedings. It goes on to define a pre-termination negotiation as any offer made or discussion held before the termination of the employment in question with a view to it being terminated on terms agreed between the employer and the employee. Section 111A also states that where there is improper behaviour during a pre-termination negotiation, then inadmissibility may be waived. Section 111A itself is fairly brief, as you can see. It doesn't say what amounts to improper behaviour, and it doesn't really give any guidance on how far pre-termination negotiations go. But it is supplemented by the ACAS Code of Practice on Settlement Agreements, and also by an ACAS guide. It's important to note that the ACAS code is non-statutory, but as with other ACAS codes, such as the Code on Disciplinaries and Grievances, it may be taken into account by a tribunal in deciding the issue of admissibility. So typically, what is likely to happen where it's contested as to whether a protected conversation is actually protected is that the employee solicitor may waive the ACAS code in front of you and say, you haven't complied with this element of it, and that's relevant to whether or not this conversation is actually protected. The guide isn't taken into account by tribunals in the same way, but it does provide some very useful guidance on protected conversations and settlement agreements, and is more a point of reference document. It includes some useful template documents at the back of it, setting out, for example, without prejudice offers, etc., to employees, and there's also a template service agreement. So it is useful to have a look at the ACAS guide on settlement agreements if you haven't already done so. So, considering one of the aims of introducing Section 111A, protected conversations, was to give greater scope for frank discussions, has that aim actually been achieved by the legislation? Well, I think the answer is yes and no. It does clearly put the ability to have this conversation on a legislative footing. And the biggest difference is that there is no need for there to be an existing dispute, which is clearly very significant. And it removes some of the uncertainty that exists under the without prejudice rule. Additionally, following a recent case, and that's the case of Faith Home Farrell Timms LLP and Bailey, which was reported very recently, it's clear that what is protected from admissibility goes much further than under the without prejudice rule, in that it protects not only the direct negotiations with the employee, whether in a meeting or in writing, but also the fact that those negotiations took place, and potentially also internal discussions about negotiations between managers and HR. However, I don't want you to think that that gives you a carte blanche to assume that all internal discussions about reaching a settlement with an employee will be protected, because what's clear is that if an employee has a claim outside the claims which are covered by protected conversations, which I'm going on to cover, such as a discrimination claim, then the same scope will not apply. So in the context of a discrimination claim, those internal conversations may not be protected. So the safest course of action is to assume that internal conversations are not necessarily going to be protected. It's better to have them face-to-face than in writing. And if you are concerned, or if you want to put anything in writing, then involve your local friendly employment lawyer, and then you can rely on legal privilege in relation to those communications. So there are also a number of significant limitations to the protected conversations laws which were brought in 2013. The first is that protected conversations only apply to what's known as ordinary unfair dismissal proceedings. So these are typically the type of claims that an employee could bring after accruing 2 years service if they are dismissed, say, for misconduct or performance or redundancy or that type of claim. All other claims are not covered. So what this means is that if an employee has another type of potential claim before a pre-termination negotiation conversation, that the conversation would not be inadmissible in respect of that type of claim. So that would include, for example, discrimination claims, whistleblowing claims, any automatically unfair dismissal claims such as dismissal due to trade union duties or serious health and safety concerns. And it would also include breach of contract claims and, for example, other statutory claims relating to working time, etc. So the scope of protected conversations is, in that sense, fairly narrow. And if you're talking about any of those other claims, you're left in the position of having to try to rely on without prejudice rule, where, as we know, you need to have a pre-existing dispute. It also does not appear to be necessary for an employee to assert that they have a particular type of complaint before the protected conversation takes place, for them later to be able to claim that that conversation is admissible. So I think what this means in practice is that you cannot be sure whether an employee will assert such a claim, and you will need to try and do the best you can to assess what potential claims an employee may have before you start that conversation, so you know what the risk is of it being outside the scope of a protected conversation. So if negotiations fail, let's say, and an employee has both an unfair dismissal claim and a discrimination claim, then an employer could be left in a situation where the content of the protected conversation is disregarded in the unfair dismissal proceedings, but is considered as evidence in relation to the discrimination claim, which clearly could pose concerns in relation to tribunals being able to ensure they are not influenced by the evidence they have heard from one claim to the other. So it's quite a tricky situation in practice in relation to how that would be dealt with if you ended up in a tribunal situation. So moving on, another significant limitation on the scope of protected conversations is that protection will be lost if there is improper behaviour. So what constitutes improper behaviour? It's generally accepted that the concept of improper behaviour is wider than the concept of unambiguous impropriety under the without prejudice rule, which, as I've indicated, tends to cover conduct which is clearly discriminatory and also where there is undue influence. And it's generally accepted that that category under the without prejudice rule is construed fairly narrowly. Section 111, as I've said, does not define improper behaviour, and it's left to the ACAS code to set out what type of conduct can constitute improper behaviour. And the code gives a non-exhausted list of improper behaviour, including bullying, harassment, discrimination, victimisation, intimidation, offensive words or threatening behaviour, physical assault. One would hope that that never occurs in any type of protected conversation meeting, or asserting undue pressure. And my view is that this last category of undue pressure is where most of the challenges are likely to arise in terms of there being improper behaviour, therefore meaning that the protection is lost. In relation to undue pressure, the ACAS code gives the following examples of undue pressure: not giving a reasonable amount of time for consideration of a settlement offer, telling an employee that they will be dismissed if they do not accept the offer. The ACAS code then also gives some examples of conduct which is unlikely to amount to improper behaviour, including where an employer factually states the alternatives if agreement cannot be reached, and where an employer sets out the written reasons that have led to the discussion. So I think that is helpful in that that clearly indicates that it is perfectly fine for an employer to indicate that if the offer isn't accepted, then there is a risk that, for example, the employee may be made redundant or dismissed, etc., subject, of course, to a process being followed. So that will still be fine and is not likely to constitute undue pressure. And clearly there is this fine line to be walked between, on the one hand, giving the employee a fair appraisal of what might happen if they don't accept the offer, and on the other hand, it coming across as a threat of dismissal if they don't accept. And I think this is where it's very important that if you have this kind of conversation with an employee, you take very careful notes. Think about having a witness there, because I've seen many occasions where what has been said to an employee has been interpreted in one way by the employee and in a different way entirely by the company, and the lack of paper trail on that issue is obviously fundamental, can be fundamental. So we have had one notable case now on what constitutes improper behaviour. This is the case of Mr. Crespigny, who I'll call Mr. C, because that's a difficult name to say more than once, and Information Security Forum Limited in 2014. And it is a fairly clear-cut case, I think, of improper behaviour, in that it was found that the employer had acted improperly for the following reasons. Firstly, no choices were given to Mr. C, and his employer effectively told him that his employment was over. He was asked to consider resigning during a so-called without prejudice meeting, and when he refused, he was told that the company had lost confidence in him and that his employment with them would be over by the following Monday, only 1 or 2 working days ahead. Secondly, he wasn't actually given any offer of settlement, nor were there any negotiations with him with a view to his employment being terminated on agreed terms. And the court found that even if an offer had been made, then the timetable was too short in the context of the date of dismissal being only 1 or 2 working days ahead. Unsurprisingly, it was also found that the without prejudice rule was not satisfied, as the employer had not demonstrated a genuine desire to resolve a dispute. So this is a fairly obvious example of improper behaviour, but when we go on to look at some of the requirements of the ACAS code, you'll see that there may be scope for arguing improper behaviour in some less clear-cut situations. So as I've said already, tribunal will take into account the ACAS code in determining any dispute over admissibility. And in this context, the code provides that parties should be allowed a reasonable period to consider the proposed settlement agreement. It then goes on to say that 10 days is generally the minimum, but a longer period may be necessary depending on all the circumstances. Clearly, in many situations, 10 days for considering a proposed settlement agreement is unlikely to be unrealistic, particularly, for example, if you have offered a proposed settlement and at that point put on hold your formal process, such as a redundancy process or a disciplinary process, where really time is of the essence and you need to get on with that process. So this can leave employers in something of a quandary as to is it necessary to offer the 10 days? Can we get away with offering a shorter period of time? My view on this is that it could be argued that if you offer less than 10 days, then there is undue pressure upon the employee amounting to improper behaviour. But I think it will very much depend on the circumstances of the case. Clearly, that allegation is not going to be made in all cases. It will depend on the nature of the employee involved, their willingness to negotiate with you. It will depend on the terms being offered. My view is that it may be that you can argue that a lesser period than 10 days is reasonable. What is going to be sensible is going to be to seek to agree a timescale with the employee at the start. So to say to them, we'd like you to come back to us by X date, can you see any issues with that? If they later come back and they do raise issues, then consider whether or not it's reasonable to extend it. However, I do think it is worth bearing in mind that this 10 days timescale is set out in the ACAS code. The code goes on to say that employees should be allowed to be accompanied to protected conversation meetings as a matter of good practice. However, it says that there's no legal requirement for this to be done. I think, therefore, it's unclear what the impact would be of failing to allow someone to be accompanied, and there's certainly been no cases to date on this issue. I think, obviously, an employer may have concerns that allowing an employee to be accompanied may well be counterproductive, in that it could delay or discourage the initiation of conversations and potentially make it harder to have those frank conversations with the employee because there's somebody else there. I certainly haven't come across many employers, if any, who've allowed somebody to be accompanied to this type of conversation, although I could see that it might be appropriate if somebody is represented by a trade union, for example. The main risk would seem to be that if somebody isn't offered the right to be accompanied, they could argue that undue pressure has been applied to them and therefore that there has been improper behaviour. But I think that as long as employees have a reasonable amount of time to take advice, they're not pressurised into decisions on the day, then I would say that allowing them not allowing them to be accompanied would seem to be unlikely to result in protection being lost. However, I think if the argument is raised, clearly you do need to give it due consideration and think about your response to that type of argument in the context of negotiations. Okay, so as you can see, both the without prejudice rule and section 11A protected conversations have certain limitations, which mean that protection can be lost or possibly not even be there in the first place. So what are the risks if protection is lost, or if the package that you put to the employee is not accepted? Well, I think the most obvious risk is the risk of claims. Firstly, there's the risk of a constructive dismissal claim arising from an alleged breach of trust and confidence based on the way in which the protected conversation has been conducted. And it's likely that an employee wishing to claim constructive dismissal would seek to allege that there has been improper behaviour during the protected conversation, meaning it's not protected, and therefore allowing them to rely on what has happened during that conversation. And in that context, a court would need to decide as a preliminary issue as to whether the protected conversation can actually be heard in evidence in support of the claim. Secondly, there's the risk that if the employee rejects the settlement proposal, and if you continue with a formal process and dismiss the employee at the end of it, that they could bring a claim for unfair dismissal. And in that context, they could argue that the conversation is not protected, and therefore that the process that followed was a sham. And typically they may argue that they were given a clear indication during the protected conversation that they would be dismissed, and therefore the following process could not be genuine in any way. So I think both of these points mean that it is important to ensure that the way in which a protected conversation is conducted minimises the risks of these potential claims. And it really all comes down to ensuring that an employee is not given that indication that if they don't accept the package, they will be dismissed. So as we've already discussed, there's also the risk of claims which are not covered by section 111A being brought because there's no pre-existing dispute. I think we've already covered that. It's just a question of being aware that that may be the case, and you may end up in a situation where you've got certain claims that could be brought where the conversation could be relied on, such as discrimination claims, and other claims where the conversation can't be relied on, such as unfair dismissal claims, which is clearly an undesirable situation, but one which could occur. Another risk, if the package is not accepted, and not necessarily if protection is lost, is the risk of grievances. There's no exemption under the section 111A legislation for dealing with grievances arising out of without prejudice or protected conversations. So what this means is that if you do get a grievance, then you would still be obliged to look at that grievance. As we know, failing to deal with a grievance can lead to a breach of trust and confidence. So it's important that you deal with that grievance and don't just rely on the fact that it arises out of a protected conversation. Even if it's a question of dealing with the grievance in terms of that conversation was a protected conversation, then you have at least dealt with it. But certainly I think it's important that you deal with the grievance and don't ignore it. The final risk is clearly more of a practical issue, in that quite often if you start down the route of having this type of conversation, the reality is that it's quite difficult for an employee to come back from it and to remain in employment if they decide they don't want to go down that route. So the risk of what happens, damage to the ongoing relationship if employment continues, is always worth considering. Is it likely that you will have to continue employing this employee if they reject the package? Or is there going to be enough really to follow through with the formal process and dismiss them for disciplinary or capability or whatever it is? If it's the situation where there isn't going to be enough and the employment continues, then clearly that may result in problems further down the line, and that's something which needs to be considered. Okay, so I've given you all the negative stuff here. I think now if we have a look at how you can go about maximising the prospect of protection in relation to pre-termination negotiations and without prejudice conversations, and also minimising the risk of successful claims. I think that it's important before opening discussions to really look at the risk profile of the employee, which will involve looking at a number of factors. In particular, whether there is a risk of a claim which is not covered by Section 111A, such as a discrimination or whistleblowing or automatically unfair dismissal claim. If there is such a claim, then are you able to rely on the without prejudice rule, i.e. is there a pre-existing dispute, and are you going to have a conversation which is a genuine attempt to settle that dispute? Clearly, if you've received correspondence from a solicitor, for example, or you've got a line of correspondence between you and the employee showing there is a clear dispute, then that may be something that you can rely on. So I don't think you can always assume that there is no dispute. It's just a question of looking at it, and again, that might be something that you would take legal advice on to determine whether or not that is the case. If there's no dispute, then you need to decide whether to proceed with the conversation in the knowledge that any type of claim which is outside Section 111A is going to be admissible. And it may be that you decide that you are going to go ahead with that conversation, but you're going to do what you can within the scope of the conversation to ensure that your defence to any subsequent claim isn't damaged. Other factors I think to take into account are whether the employee is likely to be difficult or litigious. So, if, for example, you have an employee with a long-term medical condition, clearly there may be a potential discrimination complaint there, but they've indicated they do not want to come back to work, then the chances of that employee being difficult or litigious would seem to be fairly low, and you may decide to proceed with the conversation even though there is no pre-existing dispute which would allow you to have a without prejudice conversation around discrimination. Alternatively, it might be that you have a senior employee who is, to coin a phrase, been around the block and is familiar with this type of conversation. And they may actually prefer to have this type of conversation than be taken through a process. A protected conversation may be far easier with this type of employee, as you can be much more frank with them than, say, a junior employee who is unlikely to understand really what the nature of the conversation is. So once you've decided that you're going to hold a protected conversation, my view is that there are a number of steps that you should consider taking. Firstly, it's a good idea to look at scripting the conversation, particularly if a manager is in charge of conducting it rather than HR. The trick, of course, with this is to try and make it sound like it's not scripted, which is often easier than you think, more difficult than you think. The aim will usually be to script the conversation so it makes it clear that the settlement package is optional only, as this will minimise the risk of an employee alleging constructive dismissal or that there's been improper conduct. It will also mean that if the employee has a potential claim which is not covered by the protected conversation, such as a discrimination claim, that claim can still be defended even if the conversation is admissible, because you've genuinely given the employee a choice as to how they wish to proceed, and therefore hopefully it won't prejudice your position too much. It's also going to be important that the manager conducting the conversation is aware of the need to stick to the script and not go off-piste, as I've often seen happening, and also of the risks that can create. I've often seen a situation where managers have not wanted to stick to the script because they feel it creates too much of an air of formality. They know the employee really well and they just want to be really honest with them. But as we all know, quite often honesty is not always the best policy. When the meeting commences, I'd suggest that it's explained to the employee that you wish to speak to them on a without prejudice basis and to hold a protected conversation with them, and to actually explain to them what this means, i.e. that the conversation may not be referred to in any court or tribunal process. I think that whilst this may sound overly formal, I've seen lots of cases where an employee has later claimed that they don't understand the nature of the conversation. And at the very least, I think the meeting should be followed up with correspondence which refers to the conversation as both without prejudice and also as an offer made under section 111A. Particularly important if you're seeking to rely on the without prejudice rule, as there have been cases to say that if you don't label correspondence as without prejudice, then that can indicate that you did not intend it to be so. I also think that even if you know that actually you may not be able to rely on without prejudice because there is no pre-existing dispute, it does absolutely no harm to label a document without prejudice, as it obviously indicates that that is the intention, and it may be that it's not challenged beyond that by the employee or by their advisor. The next point on the slide is to set the context. I think it's important so that the employee understands the reasons why the conversation is taking place. Sometimes it can be helpful to open the formal process first, whether it's a redundancy process where the employee is put at risk, or a performance management process, or a disciplinary investigation. Alternatively, the employee could be informed at the start of the meeting that you are considering commencing a formal process and of the reasons why. Whichever kind of approach you adopt, setting the context in this way helps to avoid the risk of constructive dismissal claims based on the fact that employees have been presented with a settlement proposal out of the blue. As I've already explained, I think it's important to avoid any suggestion that dismissal is inevitable, but also to ensure that the potential outcomes are highlighted. As I've already said, it states in the ACAS code that it's fine to make the employee aware of alternatives if they don't accept the settlement package, i.e. the risk of dismissal, but they shouldn't be placed under undue pressure to accept the offer. So some other points to think about include what is a reasonable period for consideration of the offer. As I've said, the ACAS code recommends 10 days, but clearly this will not always be realistic. If you think an employee might be difficult and therefore cite the ACAS code to you, it may be worth giving them the settlement agreement in draft at the initial meeting, so that the 10-day period clearly runs from the date of that meeting. That would hopefully avoid an argument that the 10-day period only runs from when they actually get the settlement agreement. If you have an employee who you don't think is going to be difficult, then you may decide to give them a shorter period of time. And in general, I would recommend that a period of at least 3 to 4 working days is given to confirm if they want to accept an offer, and then a further period to finalise a settlement agreement. As I've said already, you may also wish to seek agreement for the employee that they are happy to come back to you within the suggested timescale. And if an employee subsequently objects to a timescale, it would be sensible to consider giving them more time if you think their objections are reasonable, particularly if initially you gave them less than 10 days. Another point to consider is the right to be accompanied, albeit this may only be appropriate in limited circumstances. However, if, for example, you have an employee who is a member of a trade union and that representative has been involved in discussions, it may be appropriate or even helpful for the trade union representative to be present. So I've already said that it would be important to ensure that you write to the employee to confirm the discussion and that correspondence is marked without prejudice and as a offer under section 111A, the Employment Rights Act. A written offer of settlement should be labelled subject to contract. It's important to use the word subject to contract because I have seen situations where that hasn't been used and an employee has sought to claim that the full extent of the offer made to them was set out in the offer and that they were not willing to accept any further terms within the settlement agreement. So subject to contract therefore allows you to say this is going to be subject to everything that's within the settlement agreement. That said, I think if there are key terms which will apply in the settlement agreement, such as restricted covenants, confidentiality provisions, garden leave, a particular termination date, an agreed reference, the contribution to legal fees, etc., it's a good idea to set those out in the written offer so the employee understands precisely what the offer will entail, and there's not then debate down the line about the fact that something is included in the settlement agreement and not included in the offer. Another really important point on the actual terms you put forward is ensuring that the tax position is clear. I have seen the situation before where an employee has been offered a certain amount as a gross payment to them on a tax-free basis, and it's later been discovered that actually that payment can't be made because an element of it relates to notice pay, and that notice pay should be taxable. At present, there is a limit of £30,000, as I'm sure most of you know, on tax-free termination payments, but that only relates to payments which are compensation for loss of employment, which would include redundancy pay, and therefore it wouldn't include any payments which are made under the contract of employment. The extent to which notice pay can be paid tax-free is a bit of a technical issue. Essentially, it depends on whether or not there is an ability to make a payment in lieu of notice under the contract of employment. If there is, then generally speaking, you're not going to be able to pay notice pay tax-free. Additionally, HMRC sometimes looks at whether there is a custom and practice within an organisation of making payment in lieu of notices, and can argue that if, say, you had a big redundancy exercise where everyone was paid in lieu of notice, even if there isn't a pay in lieu of notice clause in the contract, that those payments are taxable. So it will be important to work out what the tax nature is in relation to the payments before you decide on the offer that you're making to the employee. Clearly, another important element will be how much you're going to offer the employee. Normally, you would look at offering their contractual entitlements and then potentially an ex gratia payment on top. Obviously, in most cases, you would not go in with your best position. You go in with an opening offer and then have a position which you would be prepared to go to if it's necessary. So at the end of the meeting, important to emphasise the need for confidentiality in respect of the process, make sure that's respected, and I will sometimes say if that confidentiality is not adhered to, that the offer may be taken off the table if you think that's a real concern. And finally, as I've already mentioned, really important to take careful notes and think about having a witness present at this type of conversation, because of course it may end up being evidence in a tribunal claim, even if you conduct it on the basis that it's intended not to be so. So the next couple of slides just set out a potential process that you could follow if you have a protected conversation with an employee on a performance situation. And it really is a summary of what I've already talked about, so I'm not going to go through it in detail. But essentially the process is ensuring that the employee is aware of the context of the conversation and that they're given two options: either they go through a performance process in this case, or they explore whether exit terms can be agreed. I think that what's important is that if they say they're not interested, then at that point, as an employee, you need to back off and proceed with the proper performance procedure. Clearly, the process I've set out on the slide is applicable to not just performance, but also potential disciplinary and redundancy situations, or where an employee comes to you and confirms that they are not happy in their role. So, we haven't had any questions so far. I've still got plenty of time for questions. I'll summarise now. I think in summary, as you'll have seen, there are limitations both to the without prejudice rule and also to the scope of protected conversations, which can mean that you may inadvertently end up losing the protection. I think if in doubt, work on the basis that the conversation may well be admissible. And the key there will be ensuring that the employee is given options, is not just told that this is the only way it's going to go, that the employee is given a reasonable amount of time to consider the offer, is given full details of the offer in writing, etc., that the correspondence is appropriately marked, that you take appropriate notes, document the meetings, and if necessary, have someone present. Also, as I've said, assessing the risk profile of the employee and the risk of claims is clearly going to be key. I'm not saying that the process I've outlined needs to be followed in every single case. It may be a case where actually you take a more risky approach because you feel that ultimately you will reach a deal with this employee, even if there may be some wrangling along the way. So you take a more direct approach. But I think that just needs to be determined on a case-by-case basis. So unless anyone has any questions, I can't see any questions coming up, then that is the end of this session of People Hour. Finished a bit early, 15 minutes early. If anything does occur to you after the end of this session, then I'm very happy to answer questions by email or send them through to your usual gunnercooke contact. If you have any feedback on this presentation, then it would be very useful to have it. Thank you very much for attending. Presentation will be available online in due course, so if any of your colleagues have missed it, then they will be able to access it online via our website. So thank you very much, and I hope you have a great rest of the day.